everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. This lesson in law is one of the UK Law Basics series, so part of our introductory lessons, and this lesson is looking at legal authority. What is the meaning of legal authority when we're looking at law? Well, we're looking really at examples and evidence that you use to support your explanations of the law, and sometimes you might even use it as part of your legal arguments. So I sometimes get my students to think of this in terms of English literature essays. When somebody writes an English literature essay, they will use quotation from a text to support what they are saying about a character or a theme, perhaps. So any point they make about a text will be followed quite often by a piece of evidence in the form of a quote. And that's what we mean here, if you like, by legal authority. But instead of quotes from texts, we're looking at legal authority in the way of statutes, cases, and then sometimes quotes perhaps from judges and legal scholars. They're the main types of legal authority one would expect to find in a law answer, mainly statutes and cases, and that's what this lesson is going to focus on today. So the two main pieces of legal authority that we're going to look at today are statutes and cases. So statutes, and look carefully at that spelling. It's not statues, it's statutes. Statutes are made by Parliament in the UK because Parliament is our supreme lawmaker. So statutes are our primary law. They're our most important law. They're above case law. And there are different ways you can say the word statute in an essay. You might just call it an act of Parliament or a piece of parliamentary legislation. They all pretty much mean the same thing. But how are they written? Well, an act of Parliament will have the name of the act followed by the word act. So, for instance, an Act of Parliament to do with school is likely to be called the Education Act. An Act of Parliament to do with the environment is likely to be called the Environment Act. Sometimes there might be treaties, particularly if you're talking about European legislation. So, for instance, the Maastricht Treaty. Now, acts and treaties would be underlined. They would always be dated. And sometimes you even refer to specific sections within an act. So, for instance, Section 142 of the Criminal Justice Act 2003 lays down the aims of sentencing in the UK. And you would write it exactly as it's got it on the screen there in your essay. Cases are laid down in courts. Look at my next video for the way courts in the UK are organised. So cases are generally called common law or case law, and it's where judges respond to specific situations. Now, cases might be examples of what is called statutory interpretation, or they might lay down specific legal principles, and they might be called judicial precedents. Again, look for later videos to discuss these two ideas. And sometimes in cases in the higher courts in the UK, a judge might make a ruling which becomes a legal principle or a point of law. So in your law answers, you will sometimes refer to cases. and they will be shown through specific notation. So they're always underlined. It might be RV and then the surname of the defendant. So it might be RV Smith, for instance. Or it could be two surnames. So it might be Smith versus Jones. Or if it's perhaps a human rights case, it might be UK versus Smith or something like that. Now, they are always dated cases, but generally you don't need to know the date for A level. There will be some cases that your teacher might say you should know the date of this, but usually you don't need that for the purposes of A level. However, all cases should be underlined. It's quite useful to underline all your cases because then the examiner can see it at a glance how much legal authority you've got in your essay. So it can sort of be a really, really quick way for an examiner to see how detailed you've done your essay. So here's an example, R.V. Cunningham. See, it's underlined, R.V. Cunningham. Names of cases can tell us an awful lot. They can tell you whether or not the case is a criminal case or a civil case. So for instance, in our example, R.V. Cunningham, because it begins with R, and R means the Crown, Regina, the Crown versus Cunningham, we know automatically this is a criminal case. However, Donahue versus Stevenson, we know automatically this is a civil case. It's not got RV or an equivalent showing the Crown or the state. It's got a surname, Donahue versus Stevenson. It also tells you who the prosecution are and who the defendant is in each case, or for a civil case like Donahue versus Stevenson, who the claimant is and who the defendant is. So Donahue is the claimant and she is suing Stevenson, the defendant. Now, as I said, quite often you won't need to know the date for cases. There will be some key cases such as these two, RVG and RVR, where it's quite useful to know the date. So for instance, in RVR 1991, the reason the date's interesting and important is because that's the date where technically marital rape in the UK was made illegal. But why have we not got a name after R? So we've got RVG and no name, and we've got RVR and no name. So sometimes the names are just initials, and that's usually to protect the person's identity. So for RVR, it's about marital rape, so we're not going to have who the R is there. RVG, G was a child, so again the identity is hidden. And sometimes in your books you will find initials following the cases which indicate which court the principle was laid down in. So RVR, the marital rape one, went to the House of Lords at the time. So quite often you will have HL afterwards. What's important though is how you use cases in your answers. So you will quite generally be taught the facts of the case. It's quite an interesting part of law. It helps you understand the principle. And when you're writing notes, it's good to have a specific format to write the facts and the points of law down. So I always encourage my students to write the facts on the left-hand side and the point of law on the right-hand side, and to always accompany a case with a picture that's going to help you to remember it. And you should always try and keep the facts of the case as brief as possible. So the aim really is for between 3 to 5 words maximum. So here, RVR, This was about two young lads, very young, 11 and 12, and they set fire to some wheelie bins. Unfortunately, the wheelie bins caught fire and spread to nearby shops and caused a massive amount of damage by fire. And they were charged with criminal damage. In my notes, I don't need to write all that down. What I do need to know, though, is the point of law, the principle that RVG laid down. And it's such an important case. It's a landmark case because it actually overruled what was called Caldwell recklessness or Caldwell objective recklessness. And it returned the law back to Cunningham recklessness. So now, whenever there is a case involving a crime such as criminal damage, and the definition uses the word recklessness, the defendant is judged according to subjective recklessness. So the defendant is judged according to whether or not he was aware of the risk and whether he took the risk. And in RVG, the boys, they were very young. They were not aware of the risk of the fire spreading, and therefore they were not guilty. Okay, another thing to look at in regards to cases is you actually don't usually need to know the facts of the case in an essay or to write the facts of the case in an essay. You would only write the facts of the case when it is specifically relevant. So for OCR A Level law, you will sometimes have to write an essay based on a scenario. So for instance, your scenario might read, David, aged 12, set light to a park bench for a joke. Unfortunately, the fire spread to nearby garages and caused considerable damage. Well, clearly, this scenario is directly linked to RVG, the case we've just been discussing. So in your answer, you would need to recognise that. And you might write something like, the courts will apply the law on recklessness in the same way as they did for RVG, which had similar facts. In RVG, two young boys caused fire damage to nearby shops after setting light to some wheelie bins. And you wouldn't need any more factual detail than that. Generally, though, the case is just put in brackets after the point of law. So if you are writing the point of law and that is laid down in a case, you just put it in brackets. So for instance, a defendant can be found to have oblique intent if he realised the consequences were a virtual certainty. Woollin. Okay, I haven't mentioned what happened in Woollin. All I've put is Woollin in brackets, and that tells you that the point of law, that in other words, oblique intent is defined in Woollin as, did the defendant realise the consequences were a virtual certainty? But you need to be careful here. You can only put the case in brackets if that case did actually lay down that point of law. So for instance, if you were to write sexual infidelity is excluded from the anger trigger for the special partial defence of loss of self-control, Clinton, that would be wrong because Clinton didn't actually lay down that point of law. Clinton didn't say that sexual infidelity is excluded from the anger trigger. That was actually laid down in the Coroners and Justice Act 2009. Clinton clarified it, Clinton illustrates it, and Clinton, if you like, confirmed that's what Coroners and Justices Act means, but it didn't actually lay down the principle. So sometimes the facts of the case are important in that they help you to explain the actual legal principle. So for instance, if we go back to Woollin, you might have wanted to follow our previous sentence, a defendant can be found to have oblique intent if he realised the consequences were a virtual certainty, Woollin, with an explanation of willing to illustrate the legal principle, to make it really clear that you've understood it. So for instance, you could follow it with, in willing, when the man threw his crying baby towards the pram, hitting the wall and killing it, he did not realise that death or GBH was a virtual certainty and therefore did not have oblique intention. And sometimes cases don't lay down a legal principle, they merely clarify it or illustrate it or emphasise it. And in which case you would use the appropriate verb and then explain the point of law. So for instance, going back to Clinton, you could say anything said or done or both related to sexual infidelity have to be excluded from the trigger, confirmed in Clinton. Or you might say, for the fear trigger, the violence need not be directed at the defendant, illustrated in Ward. So Ward doesn't lay down the principle, it illustrates it. Clinton doesn't lay down the principle, it confirms it. Or Hatter, confirm that the terms grave in character and justifiable sense of being seriously wronged should be judged objectively. It also added that the breakup of a relationship would not usually be considered grave in character. So just be really, really careful about the way you use your cases and think about, do you need to have the facts of the case at all? And where should you put the case name? Is it okay just to put it in brackets, or do you need to incorporate it into a slightly longer sentence? The question I'm often asked by students is, how many cases do I need in an answer? And it's not necessarily a straightforward question. For OCR, those of you who are studying OCR A Level, you know you have to answer 3 types of questions: a 10-mark question, a 15-mark question, and some 25-mark questions. Now, it's the 25-mark questions that this question is really relevant for. So the level 4 assessment objective 1, descriptor, says excellent knowledge and understanding of the English legal system, rules and principles. The response is accurate, fully developed and detailed. There will be excellent citation of fully relevant statutes and case law where appropriate to the question. So the sorts of words that come out here are excellent, fully detailed, excellent citation of case law. So what does that mean? Well, the examples haven't actually said exactly how many cases to get that level 4. However, most people understand and agree that you're looking at about 4 cases really for a level 4 answer. So that is certainly what I would aim for in any 25-mark question, and you might very well do more. But if you're looking for a top band answer, I would aim for at least 4 cases. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.